Hi guys, welcome to my channel, The Legal Affair with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on intellectual property. Please, of course, do remember to subscribe to our channel, The Legal Affair on YouTube. You can also follow us on social media platforms, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So when it comes to the conversation on intellectual property, we know that under South African law, there are different types or categories of intellectual property. So, number one, we have patents. Number two, we have copyrights. And number three, we have trademarks. Number four, we have designs. Now, within the classification of designs, we have a differentiation between an aesthetic design and a functional design. What we do know also in terms of South African law, when it comes to registration of intellectual property must always be registered with the CIPC. Now, the CIPC is, of course, the body or the entity that regulates the registration of intellectual property. And you have the option when you want to register intellectual property either to register directly with the CIPC, or as an alternative, you can have a third party register the intellectual property on your behalf. And the CIPC will, of course, always, once the intellectual property in question is registered, issue with documentation confirming the registration of the intellectual property. The documentation will also reflect the nature or the classification of the intellectual property, and if it is applicable, the duration that you will have the intellectual property rights. Of course, a very important conversation when it comes to intellectual property is, should one register intellectual property first and thereafter, pitch the ideal concept to a third party, or should you not register your intellectual property and, of course, just pitch the concept or an idea with an NDA? Now, when it comes to pitching concepts or an idea with an NDA, if you aren't familiar with an NDA are non-disclosure agreements, and what NDAs are intended to do, amongst other things, is to allow a person who has a concept or an idea to pitch that concept or an idea to a third party. Now, once you've pitched that concept or idea, you request that third party to sign the non-disclosure agreement, and there, you being that third party, are saying that they are not going to disclose, the pitch or the concept that you've given to them. Now, the challenge with NDAs, I think NDAs are really great agreements on paper, but there are quite a number of challenges that you face, and specifically in many instances, when it comes to NDAs and pitching concepts, it's that you'd find very big entities or corporate companies would say that once you've pitched an idea and you've requested them to sign the NDA and they sign the NDA, you'd find a month or two later or even a year later, they actually execute on your idea. Now, the challenge with that is actually proving that you are the owner of the intellectual property. So you might find that that company's argument might be that we've actually always had this intellectual property. We just listened to your pitch. Because we took interest in it, and they generally just give you a song and a dance specifically on your concept or on your idea. So in short, I don't think it's advisable to pitch a concept or an idea without having your intellectual property registered. I think what is ideal is to, number one, understand what type of intellectual property you have. So your concept, your idea, or your creative work, what type of intellectual property is it? Is it a copyright? Is it rather a design? Is it a trademark? Or is it a patent? Once you've understood that, you can, of course, opt to have the intellectual property registered. And of course, once the intellectual property is registered, you can pitch, your concept or an idea or your creative work to a third party. Now, the benefits of registering your intellectual property is, of course, if a third party decides to use your intellectual property without your permission or your consent, you can always prevent them from doing so. In other words, you institute legal proceedings or you sue them, you stop them from using your intellectual property without your consent. Another benefit, or rather a gain, for registering intellectual property first is that you can actually transfer intellectual property. So intellectual property has a commercial advantage. The trademark, the copyright, the design, or patent is something that can be sold to another person. It can be bought for another person. It can be licensed to another person. So in my view, it is quite important to actually try and understand, firstly, the classification or the category of the intellectual property that you have, and thereafter register the intellectual property, because registration obviously gives you protection as the owner of the intellectual property. Now, we've had quite a lot of examples, specifically in the public space, when it comes to intellectual property. A very interesting example is the Vodacom please call and Mr. Makete. So, if you're not familiar with this, Mr. Makete is said to be the owner of the please call me, and he's instituted legal proceedings against Vodacom, and he's in essence trying to sue Vodacom, for the benefits of the commercial gain Vodacom has had from the creation of the please call me. Another interesting example when it comes to intellectual property is House of BNG and Bonang. Now, with House of BNG and Bonang, I took particular interest in this matter because I wanted to understand who owns the intellectual property when it comes to House of BNG. Is it House of BNG that owns the intellectual property, or is it Bonang that owns the intellectual property? And from what appears to be, in the media, it seems that Bonang is only actually the owner of shares in House of BNG. So what happens is that when you are a shareholder, you are issued with a share certificate, and that share certificate confirms that you hold a certain number of shares. So, for instance, you hold 100 shares. It also confirms the classification or the category of the type of shares you have. Now, what being a shareholder means, amongst other things, is that when the company pays dividends, you of course receive a payment of dividends. But what's important about being a shareholder is that being a shareholder does not mean that you are the owner of intellectual property. So the rights or ownership of intellectual property stand independently or very differently from shareholdership. So you're a shareholder, uh, you're issued with a share certificate. When the company pays out dividends, you get a payment of dividends. What's important also to understand when it comes to being a shareholder is that being a shareholder can terminate. So you can terminate your shareholdership, you sell your shares in the particular question, and you no longer have shares in that particular company, which is what seems to have happened to Bonang. So the reality is that House of BNG, she might not own, or it appears that she doesn't own House of BNG. She only owns shares in House of BNG. So what House of BNG can actually now do is that they can use another celebrity to market the brand. So I do know it's quite obvious that quite a lot of people took an interest in House of BNG, specifically because it was Bonang who was used as the face of House of BNG. But it is always important to understand that being a shareholder does not necessarily mean that you own the intellectual property. So I think, in a nutshell, when it comes to intellectual property, it's quite important to understand the kind or the category of the intellectual property that you want to register. Is your concept or idea a copyright? Is it a trademark? Is it a design? Number two, do always try and protect your intellectual property before you actually pitch it to third party, because there are quite a number of gains or benefits once it comes to intellectual property.